Are we ready? Good afternoon, everyone. I would want at this stage to reconvene the 22nd meeting of the Joint Select Committee on National Security. At this stage, I would want to welcome those present as well as the viewing and listening audience. This meeting is being broadcast live on the Parliament's Channel 11 and Radio 105.5 FM and the Parliament's YouTube channel ParlView. As a matter of procedural guidelines, I wish to remind both the committee members and the officials to direct the questions through the chair, and we would wish that you activate your microphones when recognized by the chair and turn it off when you are finished speaking. This afternoon, we are privileged and we are happy to have with us the Learned Director of Public Prosecutions, Mr. Roger Gaspard, Senior Counsel, and the Deputy Director of Public Prosecutions, Ms. Joan Honoré Paul. Excuses have been received for the Assistant Director of Public Prosecution, Mrs. Sabrina Dugdin-Jaglal, and they are duly noted. I would want to introduce myself and the members of, I will invite the members of the committee to introduce themselves, starting with the Deputy Chairman.
Good afternoon, Chairman. Thank you. Good afternoon to the Learned Director of Public Prosecution, Mr. Gaspard, and Ms. Joan Honoré Paul. Paul Richards, Deputy Chair.
Thank you, Chair. Good afternoon, everyone. Richie Sukai, Member.
Good afternoon. I am Ayana Webster-Roy, Member.
Dal Munilal, Member.
Good afternoon, Jayanti Lachmidial, Member.
Before we begin, I'd want to just have a brief declaration of interest. I am a practicing attorney at law at the bar in Trinidad and Tobago. I wish to declare that before we begin.
Chairman, I also wish to declare that I am a practicing member at both the criminal and civil bar. And for the record, I would declare that I also worked at the Office of the Director of Public Prosecutions prior to 2010.
Chairman, also declare that I'm also a practicing attorney at the bar.
We had planned our work paper since last year, and we are now in the process and the throes of executing that work program. We have with us none other than the Learned Director of Public Prosecution, Mr. Roger Gaspard, SC, and of course the Deputy Director of Public Prosecutions. For the listening public, the Office of the Director of Public Prosecutions is established under the Constitution of Trinidad and Tobago, particularly sections 90, 1, 2, and 3. And briefly, the remit of the Office of the Director of Public Prosecutions is to institute and undertake criminal proceedings, to take over and continue criminal proceedings, to discontinue criminal proceedings. That is the nub of part of the remit of the Office of the Director of Public Prosecution. So we can well appreciate the serious constituent that the Office of the Director of Public Prosecution represents in Trinidad and Tobago. Learned Director, as we begin, I will invite you to give some opening brief remarks, not more than 3 minutes, but you have the floor.
Good afternoon again. I wish to thank this committee for the kind invitation extended to my office. I appreciate, given the prevailing winds, that there are certain concerns which might find domain within your minds as far as the criminal justice system is concerned. And I undertake, together with my Deputy Director of Public Prosecutions, to be as of much assistance as I can be this afternoon.
Director, we are very grateful. Before we start, the other members' line of questioning, I want to ask you, the committee understands from your most recent submissions that the Office of the DPP does not have a strategic plan. However, it was indicated that strategic objectives are based upon proposals from your internal steering committee. What are your particular priorities for this year into next year for the Office of the Director of Public Prosecutions?
As far as I'm concerned, the major priorities this year into next year touch on concern the issue of staff shortages, the acquiring of a suitable office for the North Office of the DPP, and of course, the persistent and perennial issue of backlog, which bedevils the criminal justice system.
Is there any specific legislation that you believe, if implemented and utilized effectively, will aid in improving the efficiency and effectiveness of our criminal justice system?
There are several bits of legislation or legislation that may go some way in alleviating the current problem which attends upon the criminal justice system. They, in my respectful view, though, might form more of the superstructure than the substrata of my concerns, since in respect of the legislation, sometimes, and very often I should say, legislation is only as effective as your resources allow. If I were to go further, Mr. Chairman, I would say that the proposed legislation, which is somewhat familiarly or popularly called a JIPA,
Yes.
which seems to target the abolishing of preliminary inquiries, that legislation has the potential to do away with the backlog of cases as that backlog pertains to residents before the district courts or before inquiring magistrates. The reason why I say that is because of the fact that even as we speak, leaving aside all the matters before the magistrates' courts by way of preliminary inquiries and so on, there are many indictments before the High Court for which there has been no trial. So the abolition of preliminary inquiries may cause indictments to reach the High Court faster. But the big question is, would accused persons have faster trials? As it currently stands, there are many indictments before the High Court going back 2, 3, 4, 5, 6, 7 years, and there has been no trial. So some people are of the view that a JIPA would move the backlog from the magistrates' courts to the High Courts. Of course, it's a dynamic situation, and in these circumstances, I know that provision is being made by the judiciary to increase the number of court judges, court space, or courtroom space, and so on. In addition to which, there's a lot of optimism riding on the prospect of the plea bargaining option, gaining currency quickly as we go forward.
Director, my knowledge will tell me, though, that the plea bargaining legislation that has been in existence for over 5, maybe 6 more, maybe upwards of that, do you think it's being adequately utilized?
The thing about the plea well, Mr. Chairman, from my experience, the legislation dealing with money laundering, proceeds of crime, trafficking in persons would have been around for a long time. But it seems as though the law enforcement agencies have become more confident and more familiar and more practiced in their investigations as those investigations pertain to those bits of legislation. So what you find happening is we are seeing more matters coming forth, although the legislation isn't new. In relation to the plea bargaining legislation, there was a lot of noise being made about the old plea bargaining act and it had to be amended and so on. I wasn't of the view that that was a real problem. Suffice it to say, the legislation that we have now is also very workable, but it's a matter of the culture which obtains in the criminal justice system. So you would find that in other jurisdictions, because greater reliance is placed on scientific evidence, as opposed to, say, IC witnesses and confessions, you find that people charged with serious offenses, they tend to believe that it is almost hopeless to try to contend with a scientific fact, as opposed to trying to contend with diminishing memory or persons misremembering facts which would have occurred many years ago. To some extent, you might say, this is circular, since what we're trying to do is to obviate the backlog.
Media, you seem to be moved to ask a question.
Thank you, Chair.
And Member Richards, as soon as we'll start with you. Go ahead.
Yes. So, through you, Chair, of course. TPP, so this is something that I have been concerned about, particularly the reliance on IC witnesses that we still have in this country, because, and I'm trying to break it down as simply as possible. One of the things we learn in Parliament as opposed to court is we need to speak very simply. An accused person before the court, what you're trying to say, might quicker decide that I will take my chances that the police will not show up and my case will be dismissed. I would rather take my chance that 5, 6, 7 years down the road when they are ready to hear my case, the witness decides that they are not going to attend, they are intimidated and they will not come. And so the motivation is simply not there, to make use of the plea bargaining process. The second aspect, though, that I want to just raise with you is that there were recently statements put out through the press that there were about 184 matters where persons wanted to plead guilty and the indictment had not been filed. Now, I don't know where that figure came from or how that figure was arrived at, where the information came from, but I would like to hear your comment on that, whether you agree with that figure, whether you, and if you could, for the benefit of the public, explain the plea bargaining process, because I think that there's a misconception from my experience where the public believes that if someone wants to plead guilty, that the state should simply accept it and it's a simple it's an administrative process as opposed to the type of negotiating process that normally happens. So I think it would be wise for you to explain that, given that public statement that was made about the 184 matters where persons wish to plead guilty.
First of all, I cannot say for sure that there are 184 matters. There are several matters. When somebody wants to plead guilty, it isn't ineluctable that the DPP's office would go with what the person is suggesting by way of an agreement to plead. More often than not, you would find that defense attorneys would make proposals that may not accurately reflect the gravity of the criminal infraction against the citizenry. I had a matter quite recently where an attorney was asking for a plea in a situation where somebody would have lost his hand as a result of a wounding. And that person was asking for a plea on the basis of an assault occasioning actual bodily harm. The penalty for assault occasioning actual bodily harm the maximum under Section 30 of the Offences Against the Person Act is 5 years. The penalty for wounding with intent is 15 years. As a decision maker in relation to a plea, one of the fundamental considerations upon which I attach my decisions is what is best in the public interest. Not what is best for the accused or the defendant, what is best in the public interest. This is a small society, and I am of the view, firmly, that one must do everything in one's power to ensure that the society doesn't lose confidence in the judicial system. It cannot be that a man loses his hand and he's no longer able to work as he did before, and somebody receives 2 years, 3 years, or a fine. That, to me, does not do justice to the gravity of the act. So to go back to what you would have intimated earlier, Senator Lakshmi Diyal, it isn't merely an administrative act. You have to consider the law. You have to consider the factual situation. You will want to consider the age of the matter. You would have some bargaining to do between the office of the DPP and the person, if represented, his attorneys, if not represented. Well, the plea bargaining act, the plea agreement act, plea bargaining act, sorry, tells us what we would have to do in those circumstances. But certainly it's not automatic, it's not an administrative act. It's an act that requires some maturity, and it's an act that requires the decision maker to keep firmly in his focus the public interest.
All right. Lieutenant Director, before I go over to Member Richards, but isn't there a parallel? So there's the plea bargaining act on one hand, but there are persons wanting to plead guilty, could be outwit the plea bargaining act. Do you not think that it may be better serve the public interest that these matters be speeded up? Do you think that they're being effectively dealt with?
I think they could be dealt with more effectively. I think they could be dealt with more speedily.
How can we achieve that, Lieutenant Director?
One of the things that should be done is that the resources of the DPP's office should be augmented. The more resources we have by way of personnel, the more persons we have to consider the files, to write summaries, because the DPP cannot be expected, or any of the senior officers, to go through each file. So you're still coming back to resources.
Thank you, Chairman. Good afternoon again, Senior.
Good afternoon, sir.
Appreciate you being here. Just interestingly having this conversation today because the country just hosted 2 days of focus on regional crime and, of course, the criminal justice system in Trinidad and Tobago and the other islands were discussed heavily. If I could just, before going to my substantive first question, there's some items that if you could be so kind as to supply in writing, I'd appreciate it, and these include each year for the last 15 years, if you have those records, I'm sure you do, 2007 to 22, if you can provide data on the following: number of cases prosecuted year by year, conviction rate, acquittal rate, in terms of human resources for each year in the past 2012 to 2022, number of senior prosecutors on staff year by year, number of senior prosecutors who left the office of the DPP, number of prosecutors acquired by the office through the normal process, categorized according to junior, mid-level, and senior, attrition rate, if you have that, and number of persons promoted and positions to which they were promoted in the office of the DPP. The Secretariat will, I'm sure, be able to send you a list of the required data, right? Appreciate it. You indicated upon the start, when the chairman asked, what will your priorities be? The office of the DPP didn't have a strategic plan, but you had a steering committee which identified priorities. Would that be correct? Yes. You identified dealing with the backlog, which is multidimensional, and staffing issues. Even before I go into the HR questions I have, if you could, because there's a diverse audience listening, and we had 3 attorneys declare their legal interest because they're trained attorneys. but very often the public misunderstands the role of the Office of the DPP and the process involved in getting cases to court or matters to court. If you could, for the wider public listening, just give an overall description, the role and function of your good office, and how matters go from start to completion in a summary matter or an indictable matter, so the public gets some context as to what the workflow is from your office.
First of all, the parameters of the office in terms of the length and breadth of our remit is informed by Section 90 of the Constitution. So Section 90 speaks about initiating prosecution, discontinuing prosecution, taking over prosecutions. Section 90 to me, and the exceptions, seems to contemplate situations where police investigations have been completed and the next stage is prosecution. The DPP's office has no investigative capacity, responsibility, or capability. Unlike, say, in the US jurisdiction, which some people get confused with, where you have the system of assistant district attorneys, you would find that in several of the district attorneys' offices, they have investigators. In this jurisdiction, the investigators, the primary investigative agency is the TTPS. So yes, you have summary matters, you have indictable matters. What is happening is, and when we say summary matters are matters triable before the magistrate's court. Some people would now say before the district courts. Before the magistrate's courts, the layperson might be better able to understand that term. In this jurisdiction, most of the summary matters are prosecuted by police officers. The DPP's office would prosecute some summary matters depending on the complexity of matters, sometimes depending on the persons charged, depending on whether or not a foreign jurisdiction is involved, depending on whether or not there are matters of national security which suggests that the DPP's office inject itself into that process. But generally, most of these summary matters are prosecuted by police officers. You also have indictable matters. Those are the more serious criminal offenses, and they are generally triable in the high court, not the magistrate's court. But the system that currently obtains in Trinidad and Tobago today is that generally, before you reach the high court for trial, you have to go through a sifting process in the magistrate's courts. And some people would say you have to go through the preliminary inquiry or committal proceeding stage, where a magistrate sits to inquire as to whether or not the allegations and evidence brought by the state are sufficient to constitute a prima facie case, so as to have the person committed to stand trial in the High Court. And a prima facie case is a case where, upon which evidence a jury properly directed might convict. So the magistrate is sitting as an inquiring magistrate. The magistrate's principal task is to assess whether or not the evidence reaches that threshold of a prima facie case being made out. After the prima facie case is made out, assuming that it is, the magistrates are then duty-bound to send the proceedings to the DPP's office with a view to the DPP now looking at the evidence to see whether or not an indictment should be filed and what or which charges should adorn the indictment. Now you might say, well, if the magistrate committed for murder, The DPP will just indict for murder. Well, that is not how it works. Magistrates have committed for an offense, the DPP would indict for another offense. Magistrate might commit for one offense, the DPP indicts for 4 offenses. Magistrate might commit for one offense, the DPP discontinues the proceedings altogether. So again, it's not a mechanical administrative act. So the filing, some people would say, why doesn't the DPP sign an indictment? The signing of an indictment is the last act after you peruse the entirety of committal proceedings in a particular matter. The last act.
Would you be an advocate, senior? Because you just mentioned the investigative remit of the police as opposed to the DPP's office. Would you be an advocate of the DPP's office having investigative powers, and how would you reconcile the duality of police and DPP investigating if that were the case?
I have mixed views on that, sir. There are times when certain matters are handled in ways which suggest that perhaps another investigative agency may have done greater justice to the matter than the TTPS. Fortunately, those times are not frequent.
All right. The next question, because you mentioned resources, and there's been a lot of conversation in the public domain about the staffing at the office of the DPP and the Judicial Legal Services Commission, and how that plays into the staff shortages. The information in the public domain indicated that you have 58 on staff prosecutors, and the complement approved by Cabinet in 2013 was 137. Our newspaper report, Newsday, March 14th, by Jensen Levin indicated that, and I still don't know what is the accuracy, whether you received 10 new attorneys. I think that was discounted. But the question related to that is, and you also indicated that a lot of the 58 attorneys you have in the office don't have a lot of court experience. Could you just distill that a bit for us? What does that mean in the context of the efficiency of the office to prosecute cases effectively?
Well, between around July, August, we would have received about 16 state council ones. Several of them have no real experience in prosecuting or in the championing of criminal law.
And this is in addition to the 58 you had before, that comprises part of the 58?
That is part of the 58. So the 58, in terms of the effective deployment of the staff, has to be discounted, subject to the training up of these 16 officers by that number, 16. So that might be more like 42.
There is also the HR issue involved. If you could walk us through the HR structure in the DPP's office, because while you have the JLSC, I'm certain that internally you'd have to assess, there's a process to assess performance and also recommend for promotion. Is that correct?
That's correct.
Walk us through the HR structure. Is there an HR manager who's championing that? Because I would imagine they would have data on attrition rates, promotion rates, and people who leave, because there had been the conversation also in the public domain about people leaving to be judges and also for private practice, which means that there must be a sense of attrition rates over the years to know how many people that you will actually need if we are to eventually get to the complement of 137. So if you could walk us through so we get a clearer understanding of what that HR function is, how it's carried out in the DPP's office, and what the process is to predict, if I were to use that word, what would be needed given the attrition rates generally over the last couple of years.
Mr. Vice Chairman, if I may, I would just make a few comments on that, and I would allow Ms. Honorary Paul to answer you more substantially, because that particular area, it happens to be her forte in the DPP's office. So she deals with most of the HR issues. But just by way of prefatory remarks, the HR department of the DPP's office is an HR department that tends to be overstated until recently, maybe a couple of years ago, the HR officers in the DPP office, or office in the DPP office, for want of a better word, it comprised one person and maybe one assistant. As we speak,
One person at what level?
an HR officer,
An acting senior human resource officer.
So there's no senior human resource manager.
No, there is not.
no,
Is there a place on the org struct for that?
There is now a place on the org struct for a chamber manager.
What does that mean?
Cabinet, several years ago, approved a chamber manager for many of the departments, many of the legal departments. Because we realized we needed such a person, last year, interviews were conducted for a chamber manager. This is a contract position. DPP and I sat in those interviews, and we interviewed several persons who had sufficient experience, we felt, to be a chamber manager. At the end of those interviews, the SHRO, the Senior Human Resource Officer, indicated to the applicants that the salary was $15,000. It is noteworthy that all of them felt that given what they were expected to do and given their years of experience, that that salary would have been insufficient. We are therefore still without a chamber manager.
So do you, to the question then, that is the overall question, do you think that the present construct of the HR function in the DPP's office is fit for purpose?
It is not fit for purpose. In fact, many of the HR functions are controlled by the Attorney General's office. In respect of the Office of the Director of Public Prosecutions, about 7 years ago, the SHRO, the Senior Human Resource Officer, and the Human Resource Officer 3 were sent to the office of the DPP. They do not have the wherewithal to change the DPP's office or to man the human resource
How much is this a
function.
contributory factor to the staff issues you're facing?
Sorry, I didn't.
How much is this HR insufficiency a contributing factor to the staff and human resource issues facing the Office of the Director of Public Prosecution?
I would say it's one of the largest factors.
I think my colleague had an intervention.
When the director indicated that HR is my forte, that is a fallback position, because my forte is prosecution. Because we do not have an HR manager or a person who is dedicated for that, I have to take on a lot
Would you be
of the
surprised
HR.
to find that people listening to this are shocked by this
I-
in an office as important as the office of the DPP? That HR, HRM is not a priority, given the articulations of the Honorable DPP about staff shortages, the comments of the JLSC, and the impact this is having on the workflow in the office of the DPP?
I would not be surprised to find that people are shocked by that.
Final question before I defer to my colleague. In regards to human resource, do you think that the office of the DPP, in an overall sense, has the kind of autonomy it needs for the recruitment, attraction of state council legal officers? And if so, even if you believe so, and if not, what would you suggest changes be made to make this process more efficient in the interest of more highly functioning office? And not to say you're not functioning highly, but I mean in terms of the impediments that you've described.
Mr. Vice Chairman, I do not think that the office of the DPP is functioning in the way that it should be functioning, given the observations made, the comments, given the comments made by my colleague. What is happening is that the persons coming to the DPP's office via two streams, as state attorneys and perhaps under contract. State attorneys are appointed not by the DPP, but by the Judicial and Legal Service Commission. The chairman of that commission is the Honorable Chief Justice. As far as contracts go, about 6 weeks ago, I had asked my colleague, Ms. Paul, to inquire from the permanent secretary, the current permanent secretary, as to whether or not I could recruit staff, or the DPP could recruit staff. And the response from the PS was that you could not recruit staff, notwithstanding the fact that you are deemed to be a chief legal officer, since a chief legal officer is different from a chief financial officer. The DPP's office has no budget. To place ads and so on, we cannot do that. That historically, and I've been in the DPP's office, next year will be 30 years. Historically, no DPP has had to recruit staff, has been asked to recruit staff, and that has never been the obligation of any director of public prosecutions, because none of the DPPs, my predecessors in office, would have been chief financial officers. Lo and behold, only Monday gone, last Monday, the Honorable Attorney General would have written to me saying that you can recruit staff. Since you are a chief legal officer, you can recruit staff. You just have to liaise with my PS. The DPP, while he's a chief legal officer in the sense that he heads this department in the criminal law division, the DPP's office, to equate the DPP as chief legal officer with a PS, in my respectful view, is a misplaced equation. Since the PS has control over certain budgetary and financial resources which no DPP has.
So you think changes, and correct me if I'm wrong, what I'm getting is you think that one of the changes that should be made is that the DPP, being the chief legal officer, even if you're not the chief financial officer, have the remit to recruit staff directly. Is that your suggestion? That would make a big difference.
At least staff on contract, because, Mr. Vice Chairman, with respect to State Council, there is the remit of the JSC, which is an independent body. So I cannot traverse in that, I cannot trespass in that domain. So I cannot recruit a State Council, it's for the JSC.
So, Director, are you saying that as the Director of Public Prosecutions, you do not have the remit to recruit any staff whatsoever?
I'm saying a bit more than that, Mr. Chairman. I'm also saying that historically, no DPP has been tasked with recruiting staff.
Let me go to Member Lachmedial and we'll come around after.
Thank you, Chair. So, there seems to be, the Director, a bit of confusion with respect to your role. Now, my knowledge of the public service, you are not an accounting officer, and therefore the recruitment of staff, from what I understand you are saying, really does not fall within your remit as a chief legal officer, correct? Right. Do you think, though, that given the role and function of your office and the importance of its independence, that the office of the DPP should be given full financial autonomy? Because I asked that question given where you started, saying that staff shortages and suitable accommodation were two of your biggest priorities and some of your challenges. And financial autonomy being given to the DPP's office would mean that you would not be depending on a line ministry to solve those problems or a service commission. I also want to ask you about a comment that you made. Well, it was reported, and I know we shouldn't believe everything that's reported, but you spoke about the fact that contract officers being hired by the Office of the Attorney General, you know, it would perhaps be more appropriate to have more permanent positions and more permanent staff, so you don't have contract officers being beholden to the political directorate for the renewal of their contract. Do you, is that correct? Is it that, you know, is that your sentiment? And do you believe that the DPP, the DPP's office, whether it's you, your HR manager, your chamber manager, etc., would be better placed and would be the more appropriate body to hire staff for your office rather than the Ministry of the Attorney General?
Thank you very much for the question. First of all, it has been more than 10 years now that I would have advocated for a budget for the DPP's office so as to ensure that we could do certain things. What seems to me to be an anomaly is the fact that other so-called independent institutions have their own budgets.
If I could just ask, for example, another organization I'm familiar with, the Financial Intelligence Unit, even though they are created as a body within the Ministry of Finance, they get something called their own line in the budget, and they're able to allocate their resources. Is that your situation, or is your situation different?
My situation is different. Let me spectacularly highlight my situation, perhaps. Some time ago, someone who occupied the chair of Attorney General had a conflict with someone who occupied the chair of DPP. During the pendency of that conflict, the DPP's office would have, or before the conflict crystallized, the DPP's office would have arranged to have a retreat and a training session with the staff. Because of the conflict, that Attorney General, in his wisdom, then decided to indicate to the DPP that because of that conflict, he's not allocated any resources for the training retreat. There's no fiction, I'm not being hypothetical. This happened as a fact, and I'm speaking from my own knowledge. So it stands to reason that if we are speaking truly about an independent office, and this is an office whose independence finds itself in the Constitution of Trinidad and Tobago, it cannot be that if we want a scanner that would turn on what is, say, the complexion of my relationship with the incumbent Attorney General or any of his predecessors. That cannot be and should not be.
Director, it would also, from my knowledge and experience as well, the persons holding political office of Attorney General, you know, there may also be conflict in that regard because of the nature of the work that you do. It may be that you would have matters before you for consideration that would seriously impact upon the incumbent Attorney General or any other person, and therefore it might affect your ability to access resources?
Hence the reason, I agree with you, hence the reason why I would have advocated very strongly, it caused a particular article to be written in the press where I advocated very strongly that the Anti-Corruption Bureau be removed from being under the Attorney General.
That's a constitutional arrangement, is it?
What is a constitutional,
The
sir?
relationship between the Attorney General and the Office of the Director of Public Prosecution.
When you say it's a constitutional relationship, if we look at the case law, there's a case coming out of the Court of Appeal going by the name of Sirumani Narayan Singh, in which the judges cleared up the relationship and interplay between the DPP and the AG.
Yes?
The AG is the line minister. And on matters of national importance and so on, the DPP is duty bound to apprise the AG as to certain developments. But the AG has no place in the executive decision-making of the Director of Public Prosecutions.
But are you saying that there is an intervention by the Honorable, the Office of the AG in the decision-making process of the DPP?
I am not saying that there are interventions by the AG. Put the incumbent aside, bearing in mind my institutional memory, there have been attempts at interference in the DPP's office. And I'm speaking from my own knowledge.
And Director, those attempts that you are speaking about, have you actioned them? Have you written about them? Have you brought them to anyone's attention?
I have.
Pardon?
I have.
All right. Go on.
All right. Director, because you brought up as well, or I think Ms. Honoré Paul brought up the issue of the chamber manager, nobody wanting to take up the role based on the salary.
Sorry, if I may. There's just one issue that you would have asked about that I omitted to respond to, and it had to do with this whole business of contract officers and more permanent staff. I just, for the record, I just want to set the stage properly. When, before Cabinet in 2013, 2014 would have approved a particular staff complement for the DVP's office, we would have indicated that we wanted that increase in permanent staff because we were moving away from contractual staff. And these contracts would usually be between the applicant and the PS, Chief Personnel Officer. So we wanted to move away from that. So we got compensation on the other side with the permanent staff. Hence the reason why those numbers perhaps were what they were.
Do you believe that because of the nature of the work of the DPP's office that it would be preferable to have more permanent legal staff and that contract staff should be more the administrative staff and so on?
Hence the reason why we made the recommendation that we made, which informed the thinking behind the 2013-2014 Cabinet Note.
Right. It would also, to me, and you could agree with me or not, might encourage people to remain, and it would help with retention of staff if they were permanent positions because of the challenges that contract staff would have. It would also perhaps allow people to hone their skills and become more specialized in the field of, in different areas of prosecutions if they were to stay on in permanent positions.
I cannot help but agree.
Okay. Let me go back to the issue of the chamber manager and his salaries now. I think, and again, based on my experience and my knowledge, prosecuting is it's very different from other legal positions within the public service. Physical, mental, emotional, psychological strain. The salaries being offered to State Counsel in the DPP's office are the same as, for example, being offered to State Counsel in the Ministry of Energy, State Counsel in the Ministry of Tourism, and anywhere else. Do you think that there's sufficient understanding and consideration being given to the salaries in your office? And do you think that you should have the financial autonomy to really set salaries, because the salaries just simply will not attract staff, and even if they attract staff, wouldn't keep staff?
I agree that salaries, they are a big issue. The people in the DPP's office who are on permanent staff are on, I believe, 2013 or 2014 salaries. There have been several, the workload would have multiplied significantly since then. There are several new pieces of legislation. There are several commendable initiatives which would have been put in train by the judiciary. And some of these initiatives are not bearing the kind of fruit that they might have had persons been more inclined to see prosecution as a career, to see themselves as being adequately remunerated for their efforts as a prosecutor, so that at the end of the day, you find that you have a heavy turnover and a hemorrhaging of staff, so that between 2019 and 2023, the DPP's office would have lost 25 persons. By any stretch of the imagination, that's very high.
25 out of how much, Director?
Well, I would say 25 out of, it's not a fixed figure because people come in and
Give
go.
an average, give me a medium, like,
The revolving
I would say 25 out of about 50, 55.
So 50%, almost 40, 50%.
Sorry, and just the advent of the and introduction of the criminal proceedings rules, that would have come after the 2013 cabinet note, which is structured. Do you think that would require you to now revisit that structure? because you have the criminal proceedings rules and the demands then that are being placed on staff, do you think that you would require further administrative staff? You know, we've now moved to electronic filing. I read your submission where you spoke about the amount of scanning to be done and record, you know, you need a total records management system to be put into place now with the criminal proceedings rules and the move by the judiciary and commendable initiative of the judiciary to have more electronic filing, electronic submissions, and so on. So do you think that that structure from 2013 needs to be revisited?
I most certainly do, because the only thing constant, it's a bit of a cliche, is change. And if other objective criteria is changing, the situation as the DPP's office needs to change. For instance, just to set the stage and perhaps sketch a more appropriate terrain, we have a situation where when those recommendations were made to Parliament, which led to Parliament approving 100+ attorneys for the DPP's office, there was no fast-track court. Murder accused were not getting bail. There were no criminal procedure rules. There was no drug treatment court. There was no children court. There were no master's courts. So you have all of these things, and you have 58 attorneys. Let me sketch it properly. The Public Defender's Office deals strictly with high court prosecutions, and they do not defense work, and they do not do all of it. Some of it goes to legal aid. They have about 28 to 30 attorneys. The DPP's office does all the courts, and there are 58. Court of Appeal, all the magistrates or district courts as they call them, which is 40-odd, and we have 58. That mathematics just doesn't work.
Go ahead, Member Lecce.
Sorry.
After
Last-
Member Sukai, you'll go directly.
A last question. Is there, now, I found it odd that so many persons, I just, you know, from my own observation, a lot of people from the office of the DPP went into public defenders departments. Some went to into the role of masters, and then quite a few ended up being elevated to the roles of to the role of judge and taking up judicial appointment. The JLSC is in charge of staffing. Now, when the JLSC is making appointments to certain positions, and they know that, because the whole system, it's a system, and it's like you're draining one component in the system and moving resources out of one office, which is your office, and putting it into other systems. Is there some sort of mechanism, or do you communicate directly with the JLSC, or do they communicate with you about if we're moving, because these are people we're talking about, so if you're moving 6 people out of your department at a senior management level and putting them into to another component within the criminal justice system, is there some sort of automatic triggering of a process to fill those positions in your department, or should there be?
I think that question might be best posed to the JLSC. As far as I know,
What's your experience then?
there's no mechanism. Let me give you an example. Between October and the 1st of December, the DPP's office in October would have had 3 deputy DPPs. I was apprised by the authorities that 2 of the deputy DPPs were to be elevated as judges. By the 1st, they were to assume as judges by the 1st of December. All the work that these 2 persons would have been doing, and they have vacation leave inside, so from the time the persons get the notification, they may become particularly anxious about losing their vacation days. So they may want to go on vacation almost immediately. In the past, once upon a time, the practice used to be that the JLSC would write or speak to the DPP or whomsoever and would ask the DPP as to when the DPP might be able to relieve this person or these persons. Well, that practice appears to have passed into desuetude.
Member Sukai, would you go?
Thank you, Chair. Through you, Lieutenant Director, Deputy Director. According to your submission on April 6, 2023, we have a total amount of matters before the court as totaling to 3,196. This was your submission on April 2023, right? And according to the 2013 approval was for a complement of 137 additional staff.
It was for 100 additional, and at that time we may have had about 37.
Right. So covered the 137. But today, what do you think that number should be? Because that is 2013. What do you think that figure? Is it the same thing? Or have you been functioning since 2013 to now? Obviously, we know that you have been functioning with half of that or even less than half. So do you think that today, to have an efficiently running DPP office, what that figure needs to be?
I would say that figure shouldn't be less than it was in 2013.
So you're calling for almost same or even maybe a little more, you suggest?
Yes, because there have been several developments since 2013 which necessitate the attendance by state attorneys. For instance, recently, the judiciary would have received the authority to have 2 additional courts. One deals with sexual offenders, and one deals with trafficking in persons. Obviously, those courts would need additional prosecutors. In 2013, you didn't have those courts.
So with the changing in the environment, and we see new courts appearing, as well as new issues appearing.
Initiatives.
New initiatives.
Yes.
Do you see that the org structure of the DPP office then to the org structure of the DPP office now has been transformed over time, obviously, to include new individuals in your structure? And do you have that org structure where we can start seeing what positions need to be filled so that, once we have that org structure, then we can understand how many additional complement do you need to your staff? And in that way now, then we can start looking at a tier level for staffing and remuneration and stuff like that, and better remuneration. Do you have something like that in place?
I would allow Ms. Honorable Paul to assist you on that particular question, with that particular question.
Good afternoon. Before 2013, when we first looked at the impending AGIPA, as it then was, the director formulated a steering committee in our office. That steering committee was made up of the most senior officers who would have had years of experience in prosecuting. And that committee came up with a structure that we felt was suited at the time for dealing with the work that we had and the work that we would have in the near future. That structure is appendixed to the Cabinet Minute 1450 of 2013. It is there. As we said in our submissions, that structure has changed somewhat because of the suppression of certain administrative offices. What we should say is that, and this is interesting in respect of your question, because we have never, from 2013 till now, got what Cabinet approved. Had we got what Cabinet approved, we may have been able to specialize as we had wished. We may have been better able to train persons. We may have had permanent staff who was willing to stay. And we would have been in a different position to the position we are in now. So that the answer to your question is, yes, we have an organization structure, that it is, perhaps what we do need is a high-level human resource person to look at what we asked for, what we now need. But I say all of that to emphasize that we never did get what we asked for. Because what we felt is that if we had got what we asked for several years ago, we would have been better able to deal with what we are having to deal with now.
Learned Director and maybe Learned Deputy Director, I sent for the estimates of 2023 because I knew somewhere during the debate, if, and I can share it with you, the criminal law department where the DPP falls under, as I understand it, today the DPP's office has set aside for it and submitted, of course, under the AGs of the Office of the Attorney General. But as the criminal law division, in that budget, there's an amount specifically allocated for the Office of the Director of Public Prosecution to hire contract staff, they don't do it in a lump sum as they would have with the FIU, but there's an amount there. Are you aware of this, Lieutenant Director or Deputy Director?
We have several cabinet-approved contract positions. We have several, and I can tell you what they are. We have, for example, 25 vacant positions for Legal Counsel 1, 4 vacant positions of Legal Counsel 2.
These are contract positions,
Contract
yes?
positions.
There's an, go ahead, madam, no,
Yes.
sorry.
And there, as of last year, there are 11 positions for senior legal counsel. Now, if one is to put that in context, Chair, we asked for permanent persons. Cabinet approved permanent persons because we, and Cabinet agreed that contract officers, there was, due to the temporary nature, the disparity in terms and conditions, contract officers just did not work for us. So it was in that context that Cabinet agreed we should get 100 more permanent legal staff. It would be and I can say that about 3 years ago, we were asked whether we wanted to take on the 25 legal officers. And we said, at this time, we have asked JLSC to fill 33 State Council 1 posts. And that is the preferred option. It must be, because that is was the best fit for us. That notwithstanding, last year, because of the movement of mid-level persons, we did interview 11 senior legal persons on contract, and we felt we had to do that temporarily because we did not have mid-level staff. You would be interested to know that out of the 11 people that we interviewed, only 4 were successful.
Well, let me see if I can chime in here, because you know the appointment, sometimes the permanent staff takes some time, but in your allocation for your budget for 2023, there's an amount allocated specifically for contract staff. So maybe, Learned Director, the Deputy Director, in the meantime, as a stopgap measure, in order to arrest the situation that you have so vividly described, and I don't know if you have, do you have the document? I will share it with you, where you have your allocation, and this is approved already, so there's no need to go anywhere else other than here and have your, well, you've told me that you don't have someone dedicated in the HR position, and that must, I mean, there must be an innovative way, respectfully, to utilize what you have legitimately to augment maybe the attractiveness of the package, to at least get someone in to assist in that function, because if you are to have your organizational structure running, you must, the Office of the DPP must have an HR function that is dedicated specifically. What I will do off camera, I will share this with you. I will share the budget because it is allocated and this is approved. In other words, this just has to be actioned by the Office of the Learning Director and you have your members. Yes?
Mr. Chair, may I weigh in? Now, we have been aware, we are aware that there is an allocation for 25 of the junior staff to come in on contract. Cabinet agreed, and we are of the view that we should have permanent staff, and there's a reason for that. We want those junior officers to stay at the office of the DPP. So in 2013, when we advanced and recommended that we want our officers to stay, what we wanted and what we advocated for and what Parliament agreed is for them to stay, for them not to have to experience the issues that you experience with contract posts, that they should be permanently made. At this time, right, so we do not want stopgap recruitment. That's what we asked for in respect of the senior officers last year, and we did not get them. But at this time, the JLSC has been asked for 33 juniors. They did supply 16, and at this time, recruitment for the rest is ongoing. We have been advised that the advertisements for State Council 1 are soon to be held. I can tell you that the interviews for State Council 3 are to be held later this month. There was an advertisement for State Council 2 in October of last year. So what we are trying to get is a permanent staff who we can train and who will stay. We are not trying to go back to a stopgap measure where you have junior officers who are there for one contract and who do not stay.
May I suggest this, and this is a respectful suggestion. The budget is there. In the meantime, temporary may very well transition to be permanent. The allocation is there. Why not utilize it? That's the question. Why not utilize it, at least so you can have the staffing, some of the staffing that you require, and they may very well transition into permanent when the advertisements are done and the JLSC does conducts the interviews. Why not utilize it?
Mr. Chairman,
Yes, Director?
I just want to get a little more nuanced in the response.
Tell me.
Apart from junior staff, we need senior staff. The current...
And maybe could just give us a sense of, in the 137, just a quick intervention, what the ratio is with junior staff, senior prosecutors that would be ideal for you?
Mr. Vice Chair, could we put that in writing at a later stage,
Yeah.
please? I
But
beg.
Director,
crave your
you were on a
indulgence.
trend of thought. You were nuancing it.
Right. What we need, apart from junior staff, is senior staff.
Yes.
Now, before you can fill a contractual post, Cabinet would have to approve the post. The post must exist.
Yes.
There's no contractual post existing for senior staff. All the senior staff, like deputy DBPs, assistant DBPs, Cabinet hasn't approved any contractual post which currently exists so that you can fill those posts by contract.
Can we not take it though? So, because when we are finished with this process, Learning Director, we will certainly be having a note, an aid memoir. We intend to action it. Can we not take it in installments then? Say we have this. Part of arresting the situation is getting at least some help in the intervening period. And relative to the permanent to the more senior staff, which, as I understand your submission, is not accounted for here, then that can be addressed in a more timely manner. Or, Lieutenant Director, you have been known to be innovative. Why can't we, at some point in time, use the allocation which is there and unused? May I ask you, how much of the allocation that we have here has been used for this year? For the hiring of contract workers at the office of the DPP?
Mr. Chairman, because of our resources or lack of resources, that's not a question that we can answer. There's a question that the Attorney General and the Permanent Secretary to the Ministry, they are in pole positions to answer that question.
Well, we certainly will have them here. But I want you to consider, Learned Director, Learned Deputy Director, the concept of at least utilizing this resource to at least bring some relief, some assistance to your good office. Do you have an accounting person assigned to the office of the DPP?
The DPP's office has no accounting persons. That's why I keep saying that the attorney, the way it is working, and I'm glad that you're asking these questions, and hence the reason why I said perhaps we need to get a little bit more nuance, because some people seem to be flying against the reality. You know. The DPP office doesn't have that support. It hasn't been provided with that support. The question arises, whose responsibility is that?
To the hiring of these persons and the persons and the utilization of this allocation, which I really had to go back and look at it. The Director, it seems that you would need to have that. And if you get it, would you be willing, would your office be willing to drill down and have this access? I'm coming to you shortly. If we make that recommendation, Mr. Caesar, we can, as the JLSC, would you be willing to access this and at least see if it can work?
Our situation is so parlous that we are not in a position to refuse assistance in this regard, notwithstanding the fact that perhaps philosophically that assistance falls below what we consider to be our maximum position.
It will not be ideal.
You can put it very, very simply like that.
Member Webster Roy. Member Munilal, you're going off.
Thank you, Mr. Chairman. Mr. Chairman, through you, Mr. DPP and Deputy DPP, thank you for being here. In describing your function, you cleared up a lot of things for me. I'm a lover of law and order, SVU, and criminal intent, so I'm being honest. Honestly, I associated what was happening here to what I saw on TV, so thank you very much for bringing some level of clarity. So you noted a number of different things. I want to make sure I'm clear in my understanding. One, you are not an accounting officer.
I am not.
You're not an accounting officer. Two, you noted that the positions you requested...
Let me just clear it up, sorry.
Okay.
Member, I'm not a chief financial officer. I prefer to put it like that. Yes.
Two, you said that the chairman indicates that why not use some stopgap measures. There's a saying, the cow starving while the grass growing, right? And you said that you couldn't because Cabinet did not approve the positions. So is it that proposals were made, submitted to Cabinet, and denied? I want to understand clearly.
The reason why, well, in some cases, proposals were made, like Ms. Honorable Paul would have spoken about our having interviewed 11 persons for senior legal officers. Those posts were created by Cabinet pursuant to recommendations that came from us. But the more senior posts, because we were of the view, and we are of the view, that those posts should be filled by permanent staff, we never made those recommendations to Cabinet.
Seeing that it is taking some time through the Judicial and Legal Service for the permanent person to come on, would you consider making a proposal to Cabinet so that you will be able to recruit at that senior level? Because I noted in your submission, you said that there's been a constant exodus of senior and mid-level, and I know that is going to affect you. That's going to affect your ability to manage caseload. That's going to affect your ability to have younger officers trained, and that is also going to affect your ability to have an effective function in office when persons go on maternity leave, vacation, etc. Have you considered making a proposal for the very senior officers to be brought on? I know it's not the ideal.
It's under consideration.
One other question for me before I hand over, because I don't want to take up too much time. What is the ideal number of senior officers? If you could have the perfect DPP's office, what is the ideal number of senior officers you would require to ensure that there is an effective, efficient DPP's office and that you're able to clear up your backlog and ensure that all matters are expedited quickly?
I would say maybe about 20. Take, for instance, in Jamaica, I think Jamaica has at least 8 or 10 deputy DPPs. Trinidad and Tobago has 3 posts.
Director, there are 58 in all, 7 senior, 58 members, but about 7 or 8 that are senior in Jamaica. I think I have.
No, I'm speaking about the posts, Mr. Chairman. I think Jamaica has at least 8 posts of deputy DPP. Whether they are occupied or not, but that might be a different issue.
You're talking on the establishment?
Yes.
Just one more. In terms of assigning, I know you have limited officers, limited resources. How do you assign? So, for example, I'm being selfish now. I'm specifically asking about Tobago. How is your Tobago? You have a Tobago office, and how is it staffed? Do you have any seniors there? How is it in comparison to other offices?
We do not have a senior in the Tobago office. We have 4 attorneys at the Tobago office, 2 state 2s and 2 state 1s. We also have a support staff. Because we have no senior, every week a senior officer from Trinidad, we try to make it every Wednesday, goes to the Tobago office to treat with administrative issues and to advise the police and the junior attorneys who are there.
Member Munilal.
Thank you. Thank you very, very much, Mr. Chairman. And good afternoon, Mr. Director and Ms. Joan. Mr. Director, after hearing you today and in the recent past, I should begin by saying that I'm surprised this office is still standing. But you have been carrying this struggle on your not too slender shoulders for some time. I have a few questions to ask and some clarification and so on that I require. Earlier you told us, and I took note of it, that you're a chief legal officer, you're not a chief financial officer, and you're not an accounting officer. Now, part of the puzzle that we are trying to understand, to grapple with, and eventually to make recommendations concerning this, is that critical role of an accounting officer function to assist with the alacrity and speed of using resources which are provided. Not that resources may not be available, but resources may be available, but there's a dysfunctional system that doesn't allow the resources to be used in the manner it is prescribed for and in a timely manner. Now, I am also sensing, not only from today, but in the recent past and so on, that there is some type of dysfunctionality in the coordination, the harmony, the cohesiveness between the Office of Director of Public Prosecution, the Attorney General, and yes, the judiciary, that there's some part of that that is not gelling for administrative and efficiency objectives. And I wanted to ask you, really, I believe it was on the 17th of March 2023, there was a somewhat long press release issued by the Chief Justice, I believe, and I'm sure you would have read it and so on. And without bringing it and reading it here for you, because I think we know what we're talking about, the author of that release made certain startling observations about the conduct of business at the Office of the Director of Public Prosecution, including matters pertaining to recommending persons, performance appraisals that is the basis of recommendations, and delays in other matters. As I said, I don't want to go through that because I have other questions and so on. And you know, I was taken aback by that. I did not see in the press or anywhere any response from the office of the DPP, whether intended or not. And I wanted to ask you first, how would you respond to those type of comments, observations, and yes, critical remarks from the judiciary? And I think this was sent out by the Chief Justice, if I'm not mistaken. Would you want to respond?
If I remember correctly, Mr. MP, it may have been sent out by the Chief Justice, but if I remember correctly, that missive would have been signed as chairman of the Judicial and Legal Service Commission. I don't want to say too much about that, but your question is, how do I respond to matters of that nature? My guttural or instinctive, I should say, response, I would have bridled that, and I looked towards the big picture. So I decided not to condescend into any particulars so as to traverse or meet certain things that would have been said by the quite Honorable Chief Justice. It's not that I cannot. I decided not to, in the interest of dealing with these matters responsibly. So whatever injury may have been caused by that missive, I was prepared to take those injuries, put them on the back seat, and drive forward with the interests of Trinidad and Tobago in mind. Because I felt that if I should engage in a public spat with the Chief Justice and the Honorable Attorney General, it may have deleterious consequences, forget about me, for the interests of justice, the public interest, and the criminal justice system.
Mr. DPP, you are suggesting that the Chief Justice or the chairman of the Judicial and Legal Service Commission was reckless and irresponsible to issue that statement in the manner that he did?
I have never suggested that. I stand by what I said earlier.
Could I ask, therefore, I understand that you were weighing the public interest and the interest in the criminal justice system. So I just wanted to clarify because I did not see any response. I didn't know if you did in any way respond or you didn't.
I didn't. I chose not to.
You chose not
publicly.
To. Publicly. Thank you. Going back to the issue of accounting officer and so on, what I am taken aback that the chairman is bringing a book that really is a book in the public domain, as a public document, to indicate to you spending and so on. What is the relationship with the Ministry of the Attorney General, notwithstanding Attorney Generals would change and so on, but the Ministry of the Attorney General and the Office of the Permanent Secretary? Is there no useful coordination to work together to expend monies to, you know, when a budget is passed in Parliament, to quickly get down to the department to know what has been passed, what is the proposal, how could we get projects off the ground, this is for you, Parliament has approved it, and so on. I'm picking up that there's little, if any, collaborative working together, notwithstanding the systemic problems that we're talking about.
Sometimes the degree of collaboration depends on the size of the permanent secretary's foot. So you would find that in the past, there were some permanent secretaries who were very proactive and with whom the DPP's office would have enjoyed many a collaborative effort. It would be uncharitable of me to say that efforts are not made to have collaboration. Of course, those efforts can be improved.
I have two questions again, Mr. Chairman, please.
Mr. Member, there was one thing that you raised and you sort of sailed away from it. You were speaking in terms of funds allocated in the budget and so on, and you were talking about accounting officers and whether I'm an accounting officer and so on.
No, we cleared that. You are not an accountant.
But I want to make one point.
Yeah.
Funds may be allocated in a budget. The permanent secretary can disburse the fund. Say,
Yeah.
the permanent
I'm
secretary
not distracted.
can decide to take fund from one vote, put it in another vote, send it here, send it there. I do not have that power, sir.
No, Mr. Director, I understand that clearly. My point then was that the permanent secretary in this system that is not the best plays a pivotal role.
Correct.
In that a permanent secretary is there, the budget is passed, the parliament close off and go home, the budget is there. The job then is for the permanent secretary, the office of the permanent secretary, to ensure that the departments under that ministry are first fully aware of what is approved, and to work with the departments, including yourself, maybe others, to ensure that you have access to the resources quickly so that you can implement your programs which you already have in the pipeline. I get the impression that this is not, in this case, this is not happening as smooth as we would like it to happen, notwithstanding the systemic problem.
Your impression is not misplaced.
Mr. DPP, there has also been in the public domain another matter of grave public interest, and no lesser an office than the Prime Minister has commented on it. And that has to do, of course, with statements made. Again, I don't want to bring up newspaper here and read whatever in the public domain, concerning the occupation of a property in Henry Street, Port of Spain. We know the property. And the Prime Minister made an issue that that was there for so long and not a foot went in, and they wanted bulletproof glass and then bulletproof wall and blah, blah, blah. What is the status of that, to your knowledge, today? And what really has been the problem after so many years? Could you just, is it possible at all for you to put your finger on the button and tell us, look, this has been the problem?
The problem, sir, is that the premises allocated for the DVP's office, I first visited those premises in 2016. I expressed certain concerns, especially given where the premises were located. That notwithstanding, because of our spatial needs and the difficulty of finding suitable accommodation in Port of Spain, I was of the view that we should still try to occupy that building. But that occupation, especially given where the building is located, would have been subject to certain, I am not an expert in that area. The expert in the area is special branch. And I would have asked the special branch to do some security vetting on the building. They did so. They would have provided at least 6 reports. And in those reports, the special branch made certain observations. Why I'm speaking somewhat in a Delphic way is because, unlike other persons, I do not want to put into the public domain the vulnerabilities which are attached to that building. So I don't want to get into the detail, but suffice it to say, for your purposes and the purposes of the committee today, my reluctance to take my staff into that building was predicated upon what the experts said about the building, the experts being the special branch, and something that nobody wants to say in the public domain, but that I would say, recommendations to show up the vulnerabilities of that building didn't first come from special branch. It came from the Ministry of National Security and the technocrats of the Ministry of the Attorney General, not Roger Gaspar, the DPP. I always said, I do not have the expertise, that is not my forte, to evaluate security concerns, not even perhaps at my home.
Mr. Director, again, I really don't want to get into, and I will not be asking you anything to do with, the content of any report on security and where and so on. But could you give this committee at least some idea of the year or the month and the year when that report, that special branch report was done?
Well, remember I would have said, you're speaking in the singular, and I'm saying there are at least 6 reports.
Then could you tell us, to your knowledge, if possible at all, the period in which those 6 reports
I
would have
think
been?
it's between 2020 to 2023.
So over the last 3 years or so.
Yes.
And has that matter to this date been resolved in any way?
Last Friday, the Attorney General, myself, Mr. Honorable Paul, and other officials, including the special branch personnel, the technocrats from the Ministry of the AG, we paid a visit to that building and we had a 2-hour meeting. There were certain items discussed, and there is to be a follow-up meeting pending a report from the special branch, a more recent report.
It's a 7th report.
Well, a more recent report.
A more recent report.
Thank you.
And the final question area. Again, I ask you things in the public domain so that you can probably give us the benefit of your 30 years service. Recently, there's a recommendation, I believe yesterday or so, because we are dealing here with crime and we are concerned with illegal firearms and so on. This committee, that has been part of our mandate, concerning banning assault rifles and the impact that may have on crime. On Monday and Tuesday, there was a symposium. In fact, I didn't glimpse you at that symposium, but
I wasn't there,
I'm
sir.
sure I missed. Oh, you weren't there. Okay. You were invited, I'm sure.
Yes.
Right.
He was invited, but he didn't attend.
I'm sure that Mr. Director would have had better things to do with his time, Chairman. Chairman, please, this is my final question. Mr. Director, your views on this matter of the assault rifles banning, what impact you believe that may have, if any at all? I don't know.
That is not really my area of expertise, so I'm very reluctant to express any opinions on that. I like to be safe, so I would sail my boat as close as possible to prosecutorial horizons.
Which we appreciate very much. Thank you.
Member Lakshmi Dayal, you have a burning question if you can't.
Because it's just a follow-up
All
from
right,
one
and
of the
then
questions that was asked about the building. There was a public handing ceremonial key handing over ceremony in 2020, I think from NIDCO, who had responsibility for that building. Was any assessment, security assessment, done on the building prior to that handing over of the building from NIDCO?
I wouldn't be able to say. I'll be speculating.
Learned Director, let me try to bring the ship back a little closer to the horizon of the nub of our discussion, which is an inquiry into the criminal justice system in Trinidad and Tobago and to determine strategies to achieve greater efficiency and effectiveness. Learned Director, you've had 30 years experience. I think you've been Learned Director since 2009 or 10, is it? 2000
March 2010.
March 2010. What can you do to improve the workings of your office that will improve and achieve greater efficiency and effectiveness towards making the criminal justice system better? Your office, what within your purview, what can you do? What would you recommend?
Because of the nature of the problems which currently beset the DPP's office, I think what I can do, given what I've been doing, bearing in mind what I would have been doing all the while, is to perhaps try and ensure a greater collaboration between myself, my office, and the respective stakeholders in the criminal justice system.
Who would you, or what entities would you identify as, or are, the major stakeholders in the criminal justice system?
The institutional stakeholders would be the Honorable Chief Justice, the Attorney General, the Public Defender's Office, Legal Aid perhaps. These would be the police.
The police.
The police are integral. I think the DPP's office already has a very good relationship with the TTPS. So that institution may need the least work.
And you are committed to work with the other entities to making this criminal justice system more efficient.
As I had indicated in my opening remarks.
One other, what about promotions within the office of the DPP? Have you been actively pursuing promoting persons or Madam Honorary Paul?
I would allow Ms. Honorary Paul to deal with that.
And tell me, what are the effects or what are the results of this exercise? Bearing in mind the challenges, of course, that you have presented. Paul, Rishi, yeah. Go ahead, madam.
Thank you, Chair. I can say that in 2021, we had felt that the location in Port of Spain was nearing completion, and we felt that the recommendations of Special Branch were being looked at, so we did ask for 33 State Council 1. We did ask JLSC to advertise and acquire. At the same time, we asked for 3 persons holding the State Council 2 posts to be promoted, and 5 persons to be promoted to Senior State Council. We also asked that 17 persons be promoted to State Council 2. Those promotions did take place in 2021, and therefore 2 years have elapsed since those persons were promoted.
But
we have now made recommendations that they act in higher posts.
Before 2021, what was the promotion?
I would crave the chair's indulgence to give you that information.
In writing?
In
Member Richards, we are going round robin, one question. We're coming around.
That's Chairman is restricting me to one question, DPP. So I'll put part A and part B. Let me also, I was thinking about statements you made that you've spent 30 years in the office of the DPP.
Approximately.
And that, I'm making a presumption about your age here, it's clearly about half your life, almost.
Yes, sir.
And 15 years at the helm, that is a great deal of contribution. So I'm sure you have a great deal of institutional knowledge that you bring to bear, and I commend you for that. In your submission dated April 6, 2023, the following breakdown of matters currently being prosecuted by the Office of the DPP was provided. Appeal Court 70, Assizes 979, District and Children's Court 2,120, for a total of 3,169. That would be correct? That you're prosecuting presently. The Judiciary Annual Report 2020-2021 indicated as at July 31st, 2021, 75% of matters at the Criminal High Court are 5 plus years old, with 40% 10 plus years old. A lot of this conversation reignited with your decision to discontinue the airport scenario, that'd be correct, which really spoke about an 18-year delay. Could you identify, as part A of the question, because you indicated backlog is one of your priorities earlier on, if it is chronological, what year have you reached in clearing backlog? And part B, is there a criteria that can be optioned for the DPP to apply when determining a case is sufficiently urgent? You mentioned in the public interest earlier on, and what is in the national interest, to warrant the filing of an indictment for urgent action by the courts?
Thank you very much, Mr. Vice Chair. First of all, indictments would be filed chronologically. But an offense may be committed, say, in 2010. Another offense is committed in 2012. But the offense committed in 2012 may reach my office before the 2010 committal proceedings. So although 2012 obviously is after 2010, that one would engage your attention before the 2010 offense. So it isn't done chronologically. But apart from that, you also have an issue where you have a fast-track court and you have plea bargaining. Usually, in relation to these two areas, there's the necessity to file an indictment. So if matters come on the fast-track court, you find you would treat with them as fast-track matters. So they may drum the queue.
And what would qualify for a fast-track matter, as an example?
The way how it works is that accused persons would say, I want to plead guilty. There's the usual way. And it becomes a fast-track matter. They do not always plead guilty. They use that as a colorable device to drum the queue sometimes.
Notice of intention to plea.
Right. Correct.
But do not have to follow through.
No.
Thank you, Chair.
No,
Through you.
before you go, sorry, member
Part B?
Part B. Part B. About what would cause you to file an indictment urgently. Now, if you look at the jurisprudential underpinning, say, of the children court, you want people who are children to be tried as children. You don't want them to be tried when they are 45. And in Trinidad and Tobago, a child is somebody who hasn't attained the age of 18. So matters from the children court, one would expect you to give that priority. Matters involving elderly people, one would expect you to give that priority. Matters involving active requests for plea deals, one would expect you to give that priority. Matters which have attracted judicial review considerations, one would expect you to give those priority.
Mr. Member
Chair,
Sukai.
thank you. The DPP, I just want to, we spoke briefly about the Tobago office. Could you just give us a little insight about the South office, I believe, in Gulf City? If you just give us a little run on what's going on with that, how is it staffed, how is the facility, please?
Ms. Ordinary Paul is the Deputy DVP, and she is attached to the South office, and that is her domain.
Thank you. I spoke before about the recommendations of the steering committee. When Cabinet approved our new staff complement, as a corollary to that, you had to have more space. And at the time, we asked for an office in Tobago, one in San Fernando, and new premises, well, bigger premises in Port of Spain. That was in 2013. We actively saw many premises in San Fernando, and in 2023, January, 10 years later, we did move into the premises in San Fernando. They are located at the top floor of the car park at Gulf City, Laramine. There are right now 40 members of staff in the San Fernando office.
So you're occupying the office, right?
As of January 2023, yes.
Oh, okay.
Yes.
My final question. A lot has been said, and again, the public, it comes up from time to time about our low detection rate and even lower, of course, because it will be lower conviction rate. Again, you could agree or disagree with the statement, but would more emphasis at the level of law enforcement on scientific evidence, DNA, other types of forensics, CCTV, and so on, help improve detection and ultimately conviction? And apart from those things, what else could you suggest or would you recommend to help raise the conviction rates that you would have? And do you know by chance what your conviction rate, an average of what it might be right now?
I wouldn't be able to tell you that off.
Okay, no problem.
Off.
But what do you think you could do, or what else could be done that would help to raise that conviction rate?
The first thing is training. Training ought to be augmented for the police and for the prosecutors. Remember too, when you speak about conviction rate, and there's something that people seem not to consider. Most of the prosecution in Trinidad and Tobago, if we're looking at numbers, is done by the police. Most. Because most matters are in the magistrate's courts, if you're looking at sheer numbers. So training is a very important part of it. The greater reliance on scientific evidence must be a part of it. There's something that I have been observing that is causing me much disquietude. And that is, when I first started doing this job, it appears to me as though there would have been more matters in which fingerprint evidence would have been found in files. I might go a whole year and not see a file with fingerprint evidence. So we might say there's an inability to rely in a timely way on scientific evidence because of the shortcomings of the Forensic Science Center and so on. But what would we say about the inability or reluctance to rely on fingerprint evidence in criminal matters? So you have many matters where you have, say, home invasions and so. And the police would come to the DPP's office and there are no fingerprints. The men are wearing gloves. They touch up the chest of drawers. They went in the fridge. They did
What about
this,
the
they did that.
DNA, the DNA aspect of it? Is that actively being used?
The DNA aspect of it is being used, but not enough. And from time to time, the Forensic Science Center had certain problems so that matters had to be sent abroad. And it is in the public domain that the Minister of National Security said that a new Forensic Science Center will be ready by 2025. There are many challenges which are turned upon the Forensic Science Center, and anybody who wants to say otherwise is pretending.
Director, sorry, I actually had asked recently for a breakdown of exhibits that were awaiting analysis, and it came up to something like 16,000. In my mind, that meant 16,000 cases or so files or something sitting down and cannot proceed. Is there, what the response that was given is that the bringing on stream of CIRU would somehow help with that backlog when it came to firearms. And of course, there's a particular concern about firearm offenses. But my understanding, and I asked this question a couple of weeks ago at this committee, is that even when CIRU, in whatever capacity they are operating under, collect evidence from items, certain items, it still goes to the Forensic Science Center. And so if the Forensic Science Center cannot process it, then every offense that deals with a firearm is delayed in the courts. And does it also affect your ability to make a decision on a file when forensic reports aren't ready in relation to firearms and ammunition specifically?
The answer to both your questions is in the affirmative, but what you find happening is that sometimes I would make a decision on a file, notwithstanding the fact that the evidence as it pertains to a firearm or a blood sample is not yet ready. Hopefully, the residual evidence is such that you can go forward, notwithstanding the fact that we have a lag at the Forensic Science Center.
Member Webster Roy.
Thank you, Mr. Chairman. Mr. DPP, my final question to you, what is the stance of the Office of the DPP on, as regards to electronic submissions of documents?
The DPP's office has no problem with the electronic submission of documents, and this is done almost routinely in the DPP's office. We have no problem with that.
I know we now have a new Ministry of Digital Transformation, and we have this whole thrust to improve system. Is there any specific project that you have alongside the Ministry of Digital Transformation?
I would allow Ms. Paul to answer that.
While we have no project with the Ministry of Digital Transformation, one of our recommendations, and it's one of the recommendations that we are actively working on, is the digitization of our documents in the office. And because we have such a vast amount of documents, we need the manpower and the machinery to have those documents scanned and then placed into in a digital system. The case management system that was designed fit for purpose allows for, when it's operating at its peak, to, for example, speak to other systems, to speak with each other within the system, to have a paperless system. And that was one of the recommendations that we had, and we are actively working on that. Of course, we need more room, more equipment, more personnel to digitize all our files, but we are actively working on that system.
Hi, just a follow-up question to my colleague. In terms of percentage, how much, like if you have to just gauge a percentage of how much the DPP office is actually digitized, if you could just give us like a big...
I would say it's a very small percentage, and the reason for that is the recommendations came alongside personnel, it's space. So that when we acquired the space in Tobago, we started the digitization there, and that's the smallest office, the smallest number of files. And I could tell you we have almost finished digitizing the files in Tobago, but that's a very small amount. Now that we have moved into the, and I could tell you this, before we moved into the San Fernando premises that we have now, we had 2 scanners at the top of a step in San Fernando. So we now have the space for a scanning unit and the vault space to house the files. So we are actively digitizing files in the San Fernando premises. And I could say that we are, I don't think we're at more than 15%.
So once the blessing is given, let's say for the Port of Spain head office, right? Would that...
Once we acquire premises in Port of Spain that we can use, yes.
Yeah. Now, would that be adequate enough?
Yes, it would be.
So that will fill all your
because
requirements?
when we looked for space, part of what we looked for was space for a digitization unit or a scanning unit. What we also requested was bigger vaults to house the paper once we digitize all the documents. So, yes.
Okay, and do you
Member
have...
Suka, I have to. Member Munilal, go ahead, because that little director, this JSC has attracted a lot of questions from the public. So when Member Munilal is finished, I will give to you some questions that came from the viewing public. Go ahead, Member Munilal.
Mr. Director, to ask you to comment on a matter that was in the public domain in July 2022 or thereabout. But I want to place that matter in a wider context. We have seen within recent time a development which may not be new, but to me at least is more profound, where you had made a statement, I believe in July 2022 or thereabout, that there's a criminal justice unit of some kind in the Office of the Attorney General that purported to give advice to the TTPS on certain investigations, and you were in the dark on that matter. I raised that juxtaposed with a policy issue. To what extent, has the DPP office benefited or not from the preferred option of what I call the local and international subcontracting of prosecutions, where instead of giving resources to the office of the DPP, staff, equipment, personnel, and so on, training, we cancel a training program, in fact, there's this accent on giving resources instead to both local and foreign subcontract prosecutors to assist, presumably, the police and the office of the DPP. Is that an option that you see brings any benefit, yes or no, as opposed to the direct transfer of resources to the office of the DPP? The opportunities, for example, in that unit in the office of the Attorney General, I was informed, rightly or wrongly, that there are opportunities provided for officers in a ministry in terms of prosecution and training and international exposure, as opposed to officers in the office of the DPP, who has the constitutional responsibility as it is. Without going further, I don't know if you understand the question, but if you could comment on it.
I have always had abiding concerns about any unit which purports to exercise a parallel jurisdiction to the office of the DPP. I also have abiding concerns about members of the executive hiring personnel or putting resources, allocating resources to personnel outside the DPP's office without the DPP knowing anything about that, since that too has the potential to create a certain parallelism that makes me feel uncomfortable. Having said that, what you find happening is that with several matters involving complex fraud investigations or white-collar investigations, the TTPS, in my respectful view, do not quite have the expertise to investigate those matters in a timely manner without the support of, say, a firm of forensic accountants, or without the support of persons who have experience in investigating serious fraud, like persons who, for instance, may have been working with the Serious Frauds Office, say, of the UK, and who now have their own private firm. But to my mind, at the end of the day, the DPP's office should still have some say, if not the final say, some say into how that comes about. And in the past, the DPP's office hasn't always had a say.
Thank you, Lynn. Lynn directed some questions that are coming in from the public. With reference to performance appraisals, does your office now, do you conduct performance appraisals for your staff? And are there pre-established performance indicators? So one, do you? And two, are there preconditions or pre-established norms for the performance appraisal?
It would be a very, very curious situation if someone wanted to perform a performance appraisal without any indicators. That's very jokey. So, yes, there are indicators, and we do performance appraisal reports.
Compliance of public prosecutions with these performance indicators?
The person doing the performance appraisal reports, and sometimes senior staff. For instance, senior officers at the DPP office would have been tasked with doing performance appraisal reports, and then a more senior officer may evaluate it.
May evaluate reports done by the senior?
Yes.
Is there a case management system being used by the office of the DPP for the staff as it relates to matters before the courts in light of your staffing issues and in light of the court backlog?
The answer is in the affirmative, but I would invite Ms. Paul to expand.
Yes.
As I said just a little while ago, we do have a case management system that was created fit for purpose. We are populating that system. we are using it as far as it has been populated. So for example, in the Tobago office where the files have been put into the system, we can stay in Tobago and send a file to Trinidad to a senior officer to look at it and assign it to somebody. And that's how one of the ways in which the case management system works. Now, of course, I would say we have 15% or less input at this time into it, but yes, we are using it as fast as we could place data into it.
The next question I have from the public, is there an established ratio that determines the number of public prosecutors needed for, how did you get the fact that you need 128? How did you arrive at that figure? Is there a best practice figure? Is there a best practice ratio? How did you come up with that figure?
So we did not use any ratio or any best practice ratio. We looked, we used our experience to come up with the numbers. I can tell you, though, that at this very moment, somebody is looking at those numbers in respect of the best practice ratio.
So the numbers may be revised according to what is there.
Yes, that is
what
true.
is given to you. Learned Director, we did want to have a discipline and end at 4, but your presence here has generated a lot of chatter both online and you would have seen from the physical members present. We do intend, and you can tell us, you are not, you have no disquiet of coming back before us.
Not only do I have a problem with, do I have no problem with coming back?
Don't let member Lakshmi, I'll put words in your mouth. You want to come back?
I am here this afternoon at your disposal. My cutoff time isn't 4 for the purpose of this committee. Right. And if you were to invite me to come back, I would honor that invitation.
We will give you the requisite notice and the requisite framework for which to come back. I can tell you that in your coming here, we did develop some guidelines for the discourse. We, by and large, all of us, we stuck. Did you receive those guidelines beforehand, sir?
Yes, I did.
So the committee is now working within a certain framework where persons involved in the criminal justice system can feel comfortable to come before us and not in any way be taken by surprise, and we have a structure because our purpose is to try to improve the effective and efficient running of the criminal justice system. In closing, Learned Director, Learned Deputy Director, do you have anything that you wish to say to Trinidad and Tobago as it relates specifically to the criminal justice system in Trinidad and Tobago and any strategies or determining strategies that would achieve greater efficiency and effectiveness?
I would just want to say that, like any right-thinking citizen, the pedestrian pace of matters by way of carriage through the courts is something that concerns me and embarrasses me deeply, and it should embarrass all major stakeholders in the criminal justice system.
And what is the Office of the Learned Director of Public Prosecutions going to do to try to improve that or to dislodge that status quo?
Everything in my power to ensure that the pace quickens. But it's not only up to the Learned Director of Public Prosecutions. I heard somebody say in another forum that a certain office goes as quickly as another office allows. You would find that, for instance, the DPP could only go as fast as the police investigation allows sometimes. So it's about an interdependency. There's a certain correlation between certain major office holders, which perhaps might quicken the pace if it were to become more lubricated and if persons were to focus on the bigger picture and perhaps put personalities to sit on the back seat.
Well, I wouldn't want to say plaguing, but the issues that are largely in the criminal justice system, remove some of that lagly. I don't know if member Sukai would know the meaning of the word lagly. It's an old director. I'm sure you are familiar with that word.
I'm very familiar with it. We used to use that to catch birds.
To catch birds. I don't want to mention the tree that the lagly comes from. Lady Director, we are very grateful for you and the Deputy Director of Public Prosecutions having appeared before us this afternoon. We will be taking you up on that willingness to appear before us. In fact, I would want to maybe have a word with the committee so that we can have you come back one time so we finish your part of the discourse and then we move on to other entities. But we will discuss that in camera. We want to thank you on behalf of the entire committee, on behalf of the people of Trinidad and Tobago, for coming before us and giving your perspective on the improvement or the strategies that we can use to achieve greater efficiencies and effectiveness in the criminal justice system pursuant to your mandate under Section 90, 1, 2, 3 of the Constitution of Trinidad and Tobago. Thank you very kindly.
And I want to thank you, Mr. Chairman, for extending the invitation to us. The DPP's office is a public office. It's not above scrutiny. It should not be above scrutiny. And none of the stakeholders in the criminal justice system should be treated as a sacred cow.
Thank you, learned director. We would now, there are some questions that we have posed, some that you could not have answered. We will round robin. We'll send them in writing. We'll try to do it within, today is Wednesday. We'll try to get them to you by Friday, God's willing, so that we can have a quick turnaround so we can complete this part of the discourse. Because what we want to do, we want to follow our mandate under our standing orders and have a report submitted to the Parliament about ways that we can improve and achieve a greater efficiency in the criminal justice system. Director, I want to thank you.
Thank you very much.
You're welcome. We adjourn. In fact, I think we are properly adjourned. Yes. We are properly adjourned.